The information provided in this presentation and during this webinar should not be construed as legal advice. Attending this webinar does not constitute or create an attorney-client relationship between you and Spilman Thomas and Battle PLLC or any attorney associated with the firm. Material distributed during this webinar is done so with the understanding that the author, publisher, and distributor are not rendering legal or other professional advice on specific facts or matters and, accordingly, assume no liability whatsoever in connection with its use.
My name is Alex Turner, and I am a member in Spilman's Winston-Salem office. I am the co-chair of Spilman Cybersecurity and Data Protection Practice Group. I am a certified information privacy professional through the IAPP. I am barred and actively practice in West Virginia, Virginia, and North Carolina, and I represent a variety of clients in data privacy related litigation and assisting them with developing cybersecurity and data privacy policies and procedures.
Good morning, everyone. My name is Malcolm Lewis. I'm an associate here in the Winston-Salem office of Spilman Thomas and Battle. I am also a member of the Spilman Cybersecurity and Data Protection Practice Group. I also hold a CIPP US certification through the International Association of Privacy Professionals. And I think we're excited and ready to get started.
What we're going to do today is we're going to discuss about how your organization can utilize good practices in controlling the data that you hold by using an example of how the auto industry is not doing that. They are collecting a vast amount of data, and they are not using good data practices, as was recently determined by the Mozilla Foundation organization. Now, Mozilla is a company that developed Firefox, the web browser, and they've done an in-depth investigation into the data practices of various auto manufacturers.
Absolutely. In the Mozilla Foundation organization, they approached the research from a consumer viewpoint and evaluated the publicly available privacy documentation provided by each auto manufacturing company that it did a review on for each product. This included evaluating privacy policies, privacy pages, frequently asked questions, and an array of other documentation that the Mozilla Foundation were able to discover, all done for an attempt to help consumers navigate the privacy landscape as it exists within the auto industry. In doing so, the Mozilla Foundation focused on 6 areas of interest, which I'll let Alex identify further.
They focused on the kind of information that's being collected, how the data is being used by the company, how the data is being controlled, the known track record of the company for protecting user data, if the product can be used offline, and whether the privacy policy is user-friendly. And these questions are applicable across industries, and we will discuss how the auto industry did it wrong and how you can do it right.
Thank you, Alex. And again, our goal in this webinar is to assist companies from not making the same mistakes in their respective industries when engaging in various privacy practices. With that said, let's discuss whether 25 popular car brands that the Mozilla Foundation reviewed made a wrong turn as it relates to their privacy practices. In its published report, the Mozilla Foundation stated that every car brand that they looked at collects more personal data than necessary and uses that information for a reason other than to operate one's vehicle and manage their relationship with them. This is a serious concern because car companies have so much more data collecting opportunities than other company products and apps that we use, even more than our everyday smart devices in our homes, like Alexa speakers and in our cell phones.
They can collect personal data from how you interact with your car. They can collect data from your phone when you connect your phone to your car. They can gather even more information from third-party sources like Sirius and Google Maps. So they know where you're going, why you're going there, who you're going with, what you're doing there, what you're buying. There's even a discussion in there that in some cases they could determine a driver's sexual orientation based on the information they're collecting. So this is very private information about everyone who's interacting with their products. And they only want to make these vehicles more connected, not only with the manufacturer, but also with each other, so that they can have vehicles that can travel and keep certain distances to keep traffic going, and that is just a compounding of data that they're collecting, and and they're not putting in the protections necessary to protect that data.
Now, in regards to personal data sharing, 84% of the car brands, so 21 out of the 25 car brands that the Mozilla Foundation researched, say that they can share your personal data with service providers, data brokers, and other businesses. Worse, 76%, so 19 out of the 25 car brands, say that they can sell your personal data. For some, this may be the most scary percentage, but 56%, so 14 out of the 25 car brands, say that they can share your information with the government or law enforcement in response to a request. And I want to put emphasis on a request because this is not a court order or anything more formal or, you know, obligated. It's just a simple request.
So that means they can give your data about where you've been and why you've been there without a subpoena. And you've agreed to it. They provide you with a privacy notice that you likely haven't read, but there's also other incidents of them not complying with their privacy notices, because all but 2 of the 25 car brands that Mozilla reviewed earned a ding for data control, meaning that only 2 car brands, which was Renault and Dacia, which are owned by the same parent company, say that all drivers have the right to have their personal data deleted. So only if you drive a Renault or a Dacia, which in the United States none of us do, can you tell them, get rid of my data. And that's likely because those 2 car companies are sold in Europe exclusively, and they are subject to the GDPR, which has a requirement that EU countries provide that requirement that you can delete your personal data. So they've collected your data, your car is spying on you, and it's tattling on you to the manufacturers, and you can't do anything to control the data that it is sharing. And you can't tell them, look, I've sold the car, I don't want you to have my data anymore. Too bad, they still have it.
Despite the fact that 25 car brands, the Mozilla Foundation research, each had several long-winded privacy policies, with Toyota having the most, being 12, they couldn't find confirmation that any of the brands meet their minimum security standards. The Mozilla Foundation found this to be a major issue, and primarily because their major concern was that they can't tell whether any of the cars encrypt all of the personal information that sits on the cars. And that's the bare minimum privacy practice. In response, the Mozilla Foundation reached out by email seeking clarity, but was either ignored or received ambiguous responses that still did not answer the basic security questions that they were asking. Now, for your purposes, we will not be able to discuss every topic in consideration with respect to good privacy practices. However, in the interest of time and from the perspective of companies, since the Mozilla Foundation covered considerations from the consumer perspective, we wanted to direct our focus onto a few key topics on consideration, which Alex will now discuss further.
Those considerations include collecting and using the minimum personal information necessary. Only use and collect what you need. Identifying data flows to control monitoring and limit access. Not everyone needs access to this information. Bob on the loading dock at the hospital doesn't need access to medical records. The CEO of a company doesn't necessarily need access to all the HR records at their fingertips. Develop transparent and equitable privacy policies and notices. Don't bury the lead in an onerous and lengthy privacy notice. Tell people what you're going to do. Collect what you say you're going to collect. Use it the way you're going to say you're going to use it, and make changes when you need to make changes. Establish a process for review and update to ensure that no falling out of compliance with public privacy promises. If you say you're going to do it, do it. If you say you're not going to do it, don't do it. And make sure that you're in compliance with applicable federal and state laws and regulations regarding data privacy. And also have effective ways to respond to a data incident. Have a plan in place. Don't wait for there to be a data breach. There will be a data breach. It's not an if, it's a when. You just have to make sure that you have reasonable processes and procedures in place to protect against it, and that you respond appropriately. and in the time frame that is reasonable or otherwise required by law or regulation for your industry.
Now, Alex, I would like to transition into more of a Q&A for those in the audience who may be wondering what some of those key considerations we mentioned truly entail. However, before doing so, I want to state that at the outset, any company seeking to cultivate a strong and healthy privacy program should first characterize the system that is the target of privacy threats in a way that translates into being cooperative with privacy risk analysis. This is necessary in order to maintain and monitor your company's privacy practices and risks. Now, as it relates to good privacy practices such as data minimization, which we mentioned, and only collecting the minimum necessary amount of data, what is the minimum necessary?
There should be reasonable efforts made to limit the use and disclosure of personal information to the minimum that is necessary to achieve the intended business purpose. And that properly destroying old data in accordance with applicable data privacy laws that permit companies to store personal data for a certain period of time. What this means is you have to know what you have. That means you need to do an audit. At least annually, you should audit what data you're holding, why you're holding it, what you're using it for, and what you need and what you don't. And get rid of what you don't, because the more data you hold, the riskier it is in the event of a data breach. You don't want to be holding information that a bad actor can use that you didn't even need. And now you have potential liability because you were holding it. You also, if you have a whole bunch of data, you don't know what you have. You have no way to track it. It gums up the system. You're burdened by having too much data. More is not always better. And you should have a multidisciplinary team that audits the data your organization is holding. And this is not only customer data, but employee data as well. And that team should include executives, it should include HR, sales, manufacturing, depending on your industry. It should include legal, both internal and external, to come up with the proper policies and procedures you need to properly manage that data and protect it.
Great stuff, Alex. Now to transition a bit, we mentioned that this is good privacy practices we mentioned that another good privacy practice for companies is to identify data flows and how personal data is being shared. So my question to you is, what should sharing personal data look like?
This is both an external and an internal analysis. Internally, data should be siloed to only those who need to access it. There's some data that more people need to access in order to do their job responsibilities, and there's narrower ones. As an example, employee records. No one outside of HR really needs to know about the employee privacy information. Then when you share it externally, you have to make sure that what you're sharing, you're not exposing personal information of your customers or your employees to the outside, because that can also be constituted as a breach, even if it's by accident. So if you're sharing private information outside of the organization, it should be encrypted. You should identify where data needs to go and limit access to it, because again, Bob on the loading dock at a hospital doesn't need access to medical records. And you have to make sure the data is accurate. It doesn't do anyone any good to have incorrect data, to have the wrong contact information for clients, to have data that's out of date. So make sure as part of your strategy and your annual information audit, you make sure that you get rid of bad data that's no longer accurate, and that you confirm the data you do have is accurate.
Thank you, Alex. Now, as we know, sharing personal data can be for a variety of purposes, including sale purposes. However, selling personal data is an option that will be unique to every company. When engaging in selling personal data, one of the biggest considerations that comes to my mind is informed consent. We know that consent means to agree or to acquiesce. However, for consent to be informed, the data subject, being the consumer, must at least be notified about the controller's identity, who the personal data is being sold to, what kind of data will be processed, how the personal data will be used, the entire purpose of it all. But Alex, when you think about selling personal data or the selling of personal data, what comes to your mind?
First of all, you have to have clear privacy policies internally that discuss what data can be sold, who it can be sold to, and what notices that have to be given to clients and customers. And then outwardly facing, you have to have transparent policy notices to the consumer that informs them clearly, look, we're collecting this data, we're going to sell it to these types of people, just so that you know. And if you haven't informed a customer that you're selling the data, then don't do it. But if you want to, as an extra revenue stream, then you need to have an update to your policy notice and let your customers know. And then you should tell them what type of categories of entity is purchasing that so that they are aware of where their data is going and why it's going there.
Thank you. Now, staying on the topic of privacy policies and privacy notices, it is important for companies, while creating and following privacy policies and privacy notices, to keep in mind and stay up to date on laws regarding consumer preferences and rights as it relates to data access and correction. But we're stating privacy policies and privacy notices separately. Is there a difference, Alex?
Now, a privacy policy is internal. It tells your employees what data is being collected, why it's been collected, how it's going to be used, who can access it, and what to do in the event of a breach. Now, a policy notice is outwardly facing, and it tells the customers, look, we're collecting this data. This is how we collect it. This is why we're collecting it. This is what we're doing. This is how you come to us if you have a question, and this is how we're going to respond to a data breach if one were to happen.
Staying on topic again, privacy policies and privacy notices are not written down in stone. These privacy policies and notices should change as necessary, depending on the company's increasing privacy goals and efforts. However, Alex, do you mind expounding on the evolution of privacy policies and notices a bit?
If privacy policies and notices should grow with your company. They're not static, and they should be evaluated every time a change is made to the data that you're collecting and using, but at least once a year. You should sit down once a year with your multidisciplinary team and go through the data that you're collecting and make sure that it's still what you need and if there need to be changes. So if a change needs to be made mid-year, sit down and change the policies and notices, but at least every year you should go through it to make sure that you're complying with your own policy. Because if you don't comply with your own policy and there's an incident, there's increased liability. So make sure you're complying with your policy notice and your policy internal privacy policies, and then make changes where you need to make them.
Now, you mentioned, annual privacy audits. And now, for those who don't know, annual audits are procedures to ensure that your organization's goals and promises relating to privacy and confidentiality are supported by its practices. As a result, these procedures protect confidential information from abuse and the organization from liability and public relation problems. And as you were, beginning to dive further into, what specifically should an annual audit procedure look like, Alex?
It should look like a multidisciplinary group of individuals who are vested in the organization's commitment to data privacy. You want to create a culture in your organization that values data privacy. And part of that is making sure that you know what you have and how you're using it. And then implementing reasonable policies to maintain and handle that data. Now, reasonable is it relates to the size and proportional to your sophistication of your organization. A 3-person business doesn't have to implement the type of protections and data privacy that GM or Ford has to, because they're not collecting as much data, they're not exposing as much data, but they should do what is reasonable to their size and sophistication and the type of information that they're collecting. And that's what the audit helps you do. It lets you know what you have, how it's being used, how it's being stored, and who has access to it.
Now, we've been discussing a lot of good privacy practices and efforts. However, what we have not discussed is who should be conducting these good privacy practices and efforts. And that is important because an employee within your company or organization might get a request to access personal data that you are processing. And this request could come from a person that the data belongs to, the data subject, from third parties, or even employees within your own company or organization. So my question to you, Alex, is who should be dealing with these privacy efforts?
Everyone should be. This is a organization-wide effort, and like I said, you want to create a culture of wanting to protect that data. And as a leader of an organization, don't put your head in the sand regarding cybersecurity. There have been lawsuits around the country where after a data breach, board members, C-suite executives have been sued for not implementing proper protections, even though they were brought to their attention because they didn't want to spend the money on it. And as a result, there was a breach. These lawsuits are saying that they're breaching their fiduciary duty to the organization to protect the organization from not only economic, but also reputational issues as a result of a breach. And it goes from the top down. If your leadership values data privacy and all that, then it'll go down from there. Everyone will see that the CEO or the other executives are putting a priority on this. They will put a priority on it as well. And it's more than just computer networks and data privacy related to connections to the internet. This is physical too. You want to make sure if there's a filing cabinet in HR that has records in it for the employees, there's a lock on it. It's real simple. You know, people don't think of that. They only think of the big data breaches that they hear in the news, but it's little things too. It's you don't talk about, if you're in the healthcare industry, you don't talk about patients' protected health information. You don't gossip about it. That's something you keep quiet because that is protected information that shouldn't be disclosed. So it's more than just dealing with computer networks and breaches through the internet.
Alex, you bring up a good point. You know, we mentioned data incidents and data breaches, but I want to back up just for a second and ask, you know, what are some other common ways that these data incidents, data breaches occur? You mentioned the file cabinet, and if it has sensitive personal information, making sure there's a lock on it, you know, monitoring our communications with others, you know, in public spaces. What are some other common ways that these incidents or breaches may occur?
They can occur through phishing incidents where an employee gets an email that says, "Hey, I need access to your employment portal because I'm from HR," but it's not from HR. You know, confirm that anything asking for your access or credentials is actually from the person that's requesting it, and then they gain access to the back office stuff, and they can redirect your direct deposit or sit on your emails and wait for you to do a wire transfer and redirect that wire transfer. So there are a lot of different things with phishing. There's spear phishing where they target a specific person because they know that person has specific authorizations in the organization. There's device theft. You go to the bar after work, you put your phone down on the bar, you don't have it password protected, someone picks it up and they're able to access your emails. There's Trojan malware that could come in through a phishing incident. There's ransomware where a bad actor gains access to your computer network and they encrypt your data and you're unable to access it until you pay them. Now, the federal government has made it clear that they don't encourage you to pay it, but sometimes you need that data because you didn't have a plan in place and you didn't have backups in place. So now you're at the mercy of these bad actors. And there's human error. You know, you have sensitive data, you're sending it to Matt at one place, but you type in and it auto-populates with Matt at a different organization, and now you've accidentally sent an email with personal data to the wrong person. You could, like I said, you're gossiping about clients, you're gossiping about medical patients. You know, that's something that you shouldn't do. You mentioned something that's contractually private that shouldn't be mentioned on social media. These are all ways that data can be breached.
Thank you, Alex. Now, and this is my last question I have here. But to follow up on that topic, because we do know that these type of incidents and breaches occur, how should a company respond to a data incident or a data breach?
Before they respond, they should already have a plan in place and the people in place who know how to respond to this breach. So that would include IT professionals, it would include responsible executives, it would include many of the people that you've used on your team to create the audit of your information, legal, to make sure that you're complying with laws and regulations for your industry regarding the reporting of a data breach. You should have forensic IT ready to go so they can determine how the breach happened, how to stop it from continuing, and identifying the information that might have been breached. And then you need to implement the plan. And part of that is having a culture where your employees aren't afraid to come to you and say, I've found this breach, and you can respond to it. Or, look, I did something wrong. I sent an email with sensitive information to the wrong person. I apologize, but I think we need to start implementing the cybersecurity incident plan. And that group can go through and see that the person you sent it to didn't open it, that they deleted it and it's not a problem, or that you accidentally sent it to every single customer you've ever had, and now you have to make a report to the state AG, or if it's a healthcare, to the OCR, or other things. And then notify the people whose information was breached. It hurts. It hurts. It's a reputational hurt. It tells them, like, look, you might have a lawsuit against me. But the cover up is worse than the breach. That just compounds it and makes it worse. And depending on the industry you're in, it might depend on the laws and regulations, who you have to inform, when you have to inform them. And that's part of having legal involved, so that you make sure you don't miss any of the deadlines or miss any of those people you have to inform.
Absolutely. And Alex, I know that in these incidents and breaches, it can be very cost heavy. Do you mind expounding on that a bit?
You should have cybersecurity insurance, but not all insurance is the same. You have to make sure that you have sufficient coverage for the risks that you have. The more data you have, the more insurance you need. And you need to make sure you understand the coverages you have when you purchase the policy, because many times you purchase the policy, you don't understand what you have a breach, you have $50,000 in coverage, but you have to send notices to 50,000 people, and that can be hundreds of thousands of dollars, if not millions of dollars, in costs to notify people, let alone fix the problem and cover litigation. So make sure you have enough coverage to cover an incident if you have one. And again, that's proportional, and you should talk to your counsel, and you should talk to your broker about what type of policies you should be getting. And then if you have, you should have an incident response plan. If you have it, use it. That's why it's there. And when you're doing your annual audits, review that response plan too. Make sure that you're the IT person who's identified in that plan. If that person's no longer at the company, appoint someone else and let them know, hey, you're part of the incident response team. These are your responsibilities. So it's all about staying up to date and making sure your plans and your policies cover your specific needs.
Thank you, Alex. Now, in the event that we have any further questions or just any issues, who do we call?
You call Spilman. We're here to help you not only set up the policies and procedures on the front end, but if there is a data breach, to help you respond and deal with that at the end of the life cycle. We have experts in a variety of industries: financial, energy, education, healthcare, and a bunch of others that we can work with as part of the cybersecurity and data protection team, so that we can tailor our representation to you and to your industry and organization. And we're located in West Virginia, Pennsylvania, Virginia, North Carolina, Florida, and we have attorneys barred throughout the country so that we can help you wherever you're at. And you can contact me, or you can contact Malcolm or anyone else on our cybersecurity and data protection team to help you.